everybody for this another training in our series, FOIA training series. And so I will go ahead and start sharing my presentation document, my slide deck from early on here. Yes, thanks again. I am Joan Lelma. As I've introduced myself earlier, maybe one person missed it for a minute. And so this training in our series is titled Effectively Managing the DC Freedom of Information Act, DC FOIA Process. And we have a training series that is ongoing. We'll have others to follow this year. And our Director of Open Government is Nickel Allen. Chief Counsel is Lois Neal. And attorney advisors are Anthony J. Skirbo and Brandon Lewis. Paralegal specialist Kimberly Brown and IT specialist Kevin Brown. The Office of Open Government, OOG, and the Office of Government Ethics are within the Board of Ethics and Government Accountability. OEG investigates alleged ethics laws violations by district government employees and public officials and provides binding ethics advice and conducts mandatory training on DC government's code of conduct. And the Office of Open Government enforces the Open Meetings Act, provides binding OMA advice and training to public bodies on adherence to the Open Meetings Act, advocates for fair and efficient district freedom of information at DC FOIA processing by providing training and advice to DC FOIA officers, as we are doing today, and also aids agencies with implementing open government practices. BEGA's board issues an annual best practices report that recommends changes to DC FOIA. And in addition, OOG assists members of the public in filing FOIA requests with the appropriate public agency or agencies as the case may be. And if you have any questions, I should have let you know from early on, please go ahead and drop your questions in the chat. The way my screen is set up now, I will not be able to see them, but my colleagues will respond to you. You can also hold your questions for the end of the training if you'd like to ask verbally in lieu of dropping them in the chat. This presentation is divided into 5 sections, namely Introduction to DC FOIA, Responding to FOIA Requests, Conducting Searches for Records, Producing Records, and Decision Letters, Preparing Decision Letters for dispatch to the FOIA requesters. And so our introduction here, DC FOIA is a law that gives the public the right to access information from the district government. And under DC FOIA, DC government must release information that is requested unless that information is protected from disclosure. DC Freedom of Information Act also requires that DC agencies proactively provide certain information without a FOIA request. And the proactive disclosure list is on OOG's website, open-dc.gov. DC law requires that the information is available upon request and online, and it is commonly listed on the agency's website under the FOIA tab. And so it's readily accessible, it's readily identifiable that this is where the information is housed. DC government also proactively provides records and data on opendata.dc.gov. DC's public policy entitles all persons to full and complete information regarding the affairs of government and the official acts of those who represent the government. And the statute is designed to pierce the veil of administrative secrecy and to open agency action to the light of public scrutiny. The statute gives any person the right to request records in any form that are prepared, owned, used in the possession of, or retained by a public body. And if you notice, I have or highlighted here because there are times when people have seen this written and is put there, and sometimes and carries in the mind, but it's or. And the reason why I'm emphasizing this is because there are situations where the government agency did not prepare the document in its entirety, but has retained the document. And one of the examples is as it relates to contracts. So there may be a contract with a private party, a company, and the government agency, it's for a public function. And so that document is accessible to the public by way of a FOIA request. So it is not owned in its entirety by that agency, nor prepared in its entirety, but it's retained. Sometimes it's not even retained wholly, but it's still accessible. And we'll get to that further in the training. When FOIA requests are submitted, agencies are required to make a reasonable search for the records. And we emphasize reasonable here. On an annual basis, district government agencies are required to report FOIA disclosure activities for previous fiscal year to the Secretary of the District of Columbia and the Council of the District. FOIA management. Which agency is responsible for handling or processing the FOIA requests? This is the FOIA who's who. There's no central body within DC government that handles FOIA requests. Instead, each DC agency processes its own records. And the primary point of contact for DC FOIA is the agency's FOIA officer or an agency's director. The DC Mayor's Office of Legal Counsel, MOLC, handles FOIA appeals, and the DC Office of the Attorney General, OAG, handles FOIA litigation through its Civil Litigation Division and provides FOIA advice through its Legal Counsel Division. Continue on with FOIA who's who, which agency, which body handles FOIA requests. The mayor of DC has also created the District of Columbia Open Government Advisory Group known as OGAG, OGAG. OGAG advises the mayor on FOIA and other open government transparency issues. The group includes subject matter experts from the government and members of the public with expertise in open government. And by including members of the public, this demonstrates transparency, open governance, incorporating the public as much as possible, and at the same time, not infringing upon the statute in any way or any form. And so this is a wonderful way to go about enforcing government transparency. What is an agency's FOIA responsibility? So each agency head must designate an individual as its FOIA officer, and each agency must post on its website the name, title, address, telephone number, and email address of its designated FOIA officer. And so we have dealt with the agency's responsibility. When that has been done now, the weight falls on the shoulders of the FOIA officer. Agency FOIA officers are responsible for tracking, managing, and responding to FOIA requests for records in their organization's possession and control, and administering their organization's FOIA programs. The agency's FOIA officer must conduct or coordinate a reasonable search for records and respond timely to FOIA requests. And depending on the structure of an organization, of an agency, there may be a FOIA officer who is a sole person processing FOIA requests, handling FOIA requests, or it may be a larger agency where there are employees tasked with different functions to process. Sometimes there's admin staff, and it goes up the chain. And so the FOIA officer, notwithstanding, is the last person to have a say, so to speak, as it relates to the processing of the FOIA requests. And so even though we're talking about a FOIA officer and the tracking process, managing process, there are other, as you may be able to put in your, there is someone there. I ask that you please mute Christina. Thank you. And so as you can put in your agency or your organization here, and you know the function, and you know the persons who assist with the processing of FOIA requests. FOIA requesters and the FOIA request. Who can make a FOIA request? How to make a FOIA request. Any person has a right to inspect at his or her or their discretion to copy any public record of a public body, except as expressly provided by the FOIA exceptions. These are the exemptions laid down in DC Official Code, Section 2-532, subsection A. How to submit FOIA request. A request for a record of any agency may be made orally or in writing and must be directed to a particular agency. And there are times when you may have received, or if you haven't done so, it's coming in the future, requests that are not, they should not have been sent to your agency because your agency does not have those records. And so on the face of it, you can see that it is so. That request would be an NIF, no information found. And it's good to direct that requester to the agency that has the request. And even though a request may be made orally, if the FOIA officer asks the requester to submit that oral request in writing, the requester should follow that direction. So yes, it may be done orally, but also the FOIA officer can request that submit this in writing. And when it's submitted in writing, it can be mail, fax, or email. And this is laid down in DC Municipal Regulation, Section 402.3. Applicable regulations, DCMR, Section 400, etc. You'll go through, it lays down several things, the fee section, how appeal section. And so read the regulation with the DC Official Code, with the DC FOIA. DCMR contains the rules and procedures to be followed by all agencies, offices, and departments of the District of Columbia and all persons requesting records pursuant to DC FOIA. And the regulation is available online. The website is here. And also, I should have informed you from the outset that this training material will be available on OOG's website at open-dc.gov. FOIA requests must be specific. A request must reasonably describe the desired records. If possible, specific information regarding names, places, it depends on the request itself. Events, subjects, dates, files, titles, file designation, or any other pertinent identifying information. And this is laid down in DCMR as well. What can be requested? In this time when technology has advanced so much, the records that were requested years ago it has changed the types of records. We have seen addition, email messages, text messages, notes, databases, files, other communications, camera footage, video footage, photographs. What is considered a public record under FOIA? A DC government must provide public access to public records to maintain an open and transparent government. And the term public record is defined in DC official code. So we have a list of public records here. This is laid down in DC official code. Books, papers, maps, photographs, cards, tapes, recording, vote data, documentary material, and it doesn't matter the physical form or characteristics, owned, used, in the possession of, or retained by a public body. See, we have or here and not and we had explained that. We gave the example of a contract with a private company for public purpose. Public records include information stored in electronic format, DC Official Code Section 2-502, subsection 18. Electronic format now includes text messages and other applications. And there we have, I believe, exhausted this one about the contractors, that this includes any record produced or collected pursuant to a contract with a private contractor to perform a public function. And these records must be made available without a FOIA request. Employee salary, title, and employment dates, contract expenditures, budgets, manuals, policies, rules, opinions, orders, and meeting minutes of open proceedings of public bodies. And if this sounds familiar to some folks here, this goes also to the Open Meetings Act. Responding to FOIA requests. And when you think of responding to FOIA requests, some of the things that are foremost in your minds are accuracy, accessibility, and timeliness. When an agency FOIA officer receives a FOIA request, the FOIA officer must acknowledge receipt of the request via email message or other initial communication to the FOIA requester. And DC has an automated system provided through GovQA that the public may use to make FOIA requests, and DC agencies may use to process FOIA requests. The system automates the DC FOIA process. The FOIA officer should assign the FOIA request an internal tracking number or use some internal system to keep track of the FOIA request if your agency is not using the automated system. Very key here, because you want to have a good record to respond to the requesters in the event also if there's an appeal, and also for future reference internally. Responding to a FOIA request. An initial response correspondence typically includes an introduction and acknowledgement. You know, the requesters, they have sent their request, they want to know it has been received, eyes are placed on their request. Any clarifying questions, if needed, this is a place to clarify requests. Also, if you omit to clarify the request at that time, if you were undecided, this does not preclude you from thereafter seeking clarification. You can do so via email. You can do so by placing a call if the requester has provided a telephone number. In this initial correspondence, also discussion of fees if warranted, and processing track designation if you're able to provide that at that juncture. Contact information for questions, a complimentary clause, for example, sincerely, you want to keep it formal and provide the requisite information, a written signature line, your name, agency, and your title. Timing for final responses. For records other than body-worn camera recordings, the responses, the final responses must be provided within 15 business days. This is laid down in DC official code. And for body-worn camera recordings, that's 25 days. And when we speak of final responses, this must state, as it relates to the records, whether it's a denial in part, in full, state the reasons, whether it's no information found. And so it's not just a bare response without more. For it to be that final response, the FOIA request must be adequately addressed. And so an extension is permitted in unusual circumstances. And that extension is 10 days extension. And it must be done by a written notice to the requester stating the reasons for the extension and the expected date for the determination. And so if you don't state it, the requester will not know. So it's a matter, you just don't sit around and say, well, I will not complete this on time. And so invoking that extension without notifying the requester. Unusual circumstances defined in DC official code. The need to search for, collect, and appropriately examine voluminous amount of separate and distinct records that are demanded in a single request. A need for consultation shall be conducted with all practicable speed with another public body having a substantial interest in the determination of the request, or among two or more components of a public body having substantial subject matter requests. So within an agency, an organization, the records may be in different offices, they may be in different use, different stages. And so it requires not only retrieving the records, but there are times, depending on if there has been litigation, where there's some consultation must take place, maybe with the general counsel. There could have been deposition of parties who, yes, the matter is made public, but what was stated in those depositions has not been made public. And so there are certain information to be redacted. And while the FOIA officer is able to apply those exemptions ably, may not have close knowledge, personal knowledge, sufficient knowledge to apply to those particular records. And so the best thing to do in those situations is to consult the custodian or the party with the knowledge of what to do. And so in those situations, the process slows down and may require extension there. Unusual circumstances, we continue. Body-worn camera recordings covered by the subsection here of DC Official Code, section 2-532D. The inability to procure a vendor that is able to perform the reductions within the 25-day time period provided under DC Official Code. How do I take the extension? So if you're using the automated system, the feature is included. If you're outside of the system, contact the requester with written correspondence, email, or letter that details the specific statutory justification for the extension. Consequences for not responding to the FOIA request on time. DC Official Code Section 2-532, subsection E, provides that failure to timely respond to a FOIA request is deemed a denial of the request. And a requester can appeal the denial to the mayor. It's an administrative appeal, or to the Superior Court, as the case may be. How to deal with problematic requests. What if you receive a request that is overly broad? DCMR provides for this. A request shall reasonably describe the desired records, where possible, specific information regarding names, places, events, subjects, and other identifying information, as we have gone through this earlier. So where the information supplied by the requester is not sufficient to permit the identification and location of the record by the agency without an unreasonable amount of effort, the requester shall be contacted and asked to supplement the request with the necessary information. Every reasonable effort shall be made by the agency to assist in the identification and location of requested records. And so if the information that has been provided is not clear, if it's so vague, it's so broad, in lieu of trying to process it, in lieu of wasting time, starting and seeing that you will not go through with it, contact the requester from early on and seek that clarification. How does it impact my deadline if a requester refines the search? DCMR provides for this. A request is deemed received when the designated FOIA officer or agency head, in the absence of a designated Freedom of Information officer, receives the request submitted in compliance with the Act and this chapter. And so if it is not in compliance, one cannot always deem that request to have been received as a proper FOIA request. And when the FOIA officer contacts the requester for additional information, then the request is deemed received when the FOIA officer receives that additional information. And so you see, it's crucial to contact the requester from early on and seek that clarification, ensure that the requisite information has been provided. What if the requester never responds? The advice Office of Open Government has given in the past is to contact the requester at least 3 times before closing the request for lack of response. So don't treat it as abandoned the first time you reach out to the requester and that requester has not replied. And note that this is administrative advice, and we suggest that the FOIA officer contact the requester regarding the clarification at least 3 times and give them 2 weeks to respond each time. And after the 3rd contact and the 2-week time span, administratively close the FOIA request if no response has been received, and assume the FOIA requester has abandoned his or her request. And make a note of this in your files, of your attempts to contact the requester, how you made those attempts, whether it was via email, telephone call, when it was done, because you want to keep good record in the event that something happens. The requester says that the request has not been processed. The requester tries to appeal, and so you have your record, you have your copious notes to refer to. What if the request I receive is overly burdensome? Under DC FOIA, there's no authority to treat as void requests that the district believes are overly burdensome. And there's a case here that you on point you can read later on, Fraternal Order of Police. Voluminous email productions. If you're required to review a large number of emails, it may take longer than 15 business days. And your mind is probably being addressed to the 10 days extension at this time. So contact the requester and work out a production schedule. Attempt to produce the first batch within 15 business days according to the schedule agreed upon. And so when you do that, you're showing good faith. You're showing that you're making that effort. You're keeping the requester apprised of what is taking place, and also endeavoring to deliver those records as promised or response. It is still technically a denial, and the requester may appeal, but you're acting in good faith to produce the record and fulfill the request. And unfortunately, there's no remedy available to say, denial for being burdensome on government resources. Searching for records. So if we're at the point of searching for records, you know that you have acknowledged that request. You know that if it needed clarification, that has been done, because you don't want to be searching for records when you have not clarified that request. You also don't want to be searching for records when you have not informed the requester that you have received that FOIA request. Involves all who maintain records, all hands on deck. All agency employees who maintain records must assist the designated FOIA officer as appropriate with the identification of and search for responsive records. And so there are some agencies, especially on the federal side, I know that there are times, depending on the offices within an agency, that sometimes the records are not sent off to Office of Records Management, and for it to be, if it's supposed to go to Iron Mountain or wherever, it has not gone there, because sometimes they are court matters and the attorneys are still dealing with those records. And so it's very important to be able to have that connection, that working relationship within an agency, so all the employees will work together to get those records to the FOIA officer or the FOIA office, depending on the agency, how it's set up. Where do I start? Each agency should have a records officer or a person who is designated or responsible for an agency's records. And that employee should assist with locating the records requested. So examine your agency's organizational chart, as it may provide details as to who may possess a particular record. And if the request is for email or other electronic record that the Office of Chief Technology Officer OCTO maintains, you may have to request it through your general counsel. So examine the agency's records retention schedule to make sure the record requested has not been archived. What am I required to do? A FOIA officer must conduct an adequate search for records responsive to the FOIA request. And so we are seeing adequate and reasonable throughout this training. Those are words that are being reinforced in assessing whether a district agency conducted an adequate search in response to a FOIA request. Courts look not to the fruits of the search, but to the appropriateness of the methods used to carry out the search. So it's not always what has been generated, but how was this search conducted? The issue to be resolved is not whether there might exist other documents possibly responsive to the request, but whether the search for those documents was adequate. There's a case here on point. And how do I conduct an adequate search? We look to cases on this as well. An agency's search conducted in response to a FOIA request need not be perfect, only adequate. And adequacy is measured by the reasonableness of the effort in light of the specific request. And so even though we are talking about adequacy, reasonableness, and we look at one case, we look at the facts of one case, facts are specific to cases. And so, yes, what is reasonable in this situation may not be considered reasonable in another situation. The search must be reasonably calculated to uncover all relevant documents. And case on point here, Weisberg against the Department of Justice. Affidavit or declaration of search for records. When is this required? When a requester challenges the adequacy of the agency's search, or in litigation when the district seeks summary judgment, the agency or district must establish beyond material doubt that it expended reasonable efforts to uncover all relevant documents by setting forth, providing sufficient information in its affidavits for a court to determine if the search was adequate. Case on point, Nation Magazine, Washington Bureau. The agency FOIA officer should, as a matter of business practice, create an affidavit or declaration that describes the agency's search for records. What must be included in the affidavit or declaration? Provide context for the request. Describe the structure of the agency's file or record keeping system, electronic and or paper, as applicable to the request. And address if the agency has a retention policy, and was the search conducted even if the retention policy called for the disposal of the record. And so if this was done in a situation where the retention schedule called for the disposal of those records, then it shows that the search was adequate. The individual went beyond what was required. Or it could have been a situation where there's a practice that ought not to be taking place, where the records are not being disposed of in a timely manner with the record retention policy. And so if the FOIA officer has knowledge of that, operating on that history, may have done a search for the records, notwithstanding that they should have been disposed of. And we are continuing on about the affidavit. The description: an agency must describe, at least generally, the structure of the agency's file system, which makes further search difficult. And this is from the case Church of Scientology of California against the IRS. What else should my affidavit include? Explain how the agency's search was reasonably calculated to uncover all relevant documents. Detail both how the search was conducted, why it was conducted in that manner. And if only one system is searched, make it clear that the system was the only possible place that responsive records were likely to be located. So if you have a situation where it may be located in some boxes, paper records, it may be electronic, but you have only done the electronic search and you just said, well, it was going to be so time consuming and I may not find anything among the paper records. Well, that would not be good for your case. It would not be good for your affidavit, but you would have to include it anyway. So you want to do what is reasonable from the outset, what is adequate from the outset, to if it gets to the point of having to present an affidavit, that it is a strong one. Email searches. How do I conduct an adequate search? And this is from a case here again, Fraternal Order of Police. We do not know and cannot simply assume in this age of computerized connectivity that it would be unreasonable for the agency's FOIA officer to search all of the agency's email accounts, regardless of how many accounts that might be. And so this is just stretching toward technology. That is a lot that can be done in this time with technology. And so we do not take it for granted that because it seems so overwhelming, it cannot be done. Searching for records. What should my affidavit include for email searches? For requests involving email searches, explain how many email accounts exist and what the agency and or OCTO's capacity is in terms of searching them. Consider having OCTO submit an affidavit or declaration detailing where and how it searched for responsive records. And if it's unreasonable for OCTO to conduct searches of all or a large number of email accounts, OCTO must explain why. And so this is showing that all bases have been covered. Fees. Make sure that each person assisting with the search for records keeps a log or other documentation of the time spent searching for records. And DCMR lays out the 3 tiers, 3 levels of how much can be charged per hour depending on the employee's level, where there is the managerial, there's a professional, and then there is the other level. And so keep good notes, copious notes of that. Agencies may charge fees for conducting record searches and producing records in response to a FOIA request. And you have the commercial request. Those are you categorize. And so for the commercial request, you would charge reasonable cost for search, duplication, review. You have the educational request that is done. Charges are done a different way. If a news media, you can charge for a duplication, but you do not charge for a search and review. And then there is no fee to submit a FOIA request. However, you may require a requester to pay fees in advance if they have not paid for past FOIA-related fees. So if there's a history of outstanding fees, the prudent thing to do is to seek to get those fees paid upfront before creating more outstanding fees. And the FOIA requester may grant a public interest waiver for fees, and we'll explain a bit more about that as we move along. Examples of fees: searching for records, review of records. There's an hourly rate based on the pay grade of the personnel who performed the search. That's what we were talking about earlier, the 3 tiers. Photocopies, 25 cents per page. Document certification, $1 per document to certify as a true copy of the agency record. The direct cost of any service or material for which no fee has been established. So that is provided for in DC official code. And so a reasonable cost is charged at that time. And a requester may have to pay search fees even if the search does not locate any responsive records, or if records are located but are withheld as exempt. And that's laid down in DCMR as well. FOIA exemptions: documents excluded from disclosure requirements. So let us go ahead and look at our exemptions under DC FOIA. There are more exemptions, as you may know, under DC FOIA than are under federal FOIA. The exemptions under DC FOIA are patterned on and have been construed in accordance with federal law. Case in point here, Barry against Washington Post. Exemption 1, trade secrets. Trade secrets and commercial or financial information obtained from outside the government to the extent that disclosure would result in substantial harm to the competitive position of the person from whom the information was obtained. And if the wheels are turning back to that contract, that would be an example where, more likely than not, in some cases, there will be some trade secrets there coming through. Personal privacy, exemption 2, information of a personal nature where the public disclosure of the information would constitute a clearly unwarranted invasion of personal privacy. And you can think of various information there, such as social security number, home addresses. Personal privacy exception, balancing test. The FOIA officer must perform a balancing test under this exemption. And what is that? The individual's privacy interest in the material at issue must be balanced against the public's interest in disclosing it. And this public interest must serve the core purpose of shedding light on the agency's performance of its statutory duties. Balancing test, we have some examples here from cases. Washington Post case here, the privacy interests of students and teachers under investigation for the consumption of alcohol substantially outweighs the public interest in their identifying information. Another case here, Walter Thomas may disclose names, professional qualifications, and work experiences of successful job applicants, but refuse to disclose other private information such as home telephone numbers and addresses, social security numbers, marital status, and personal references, or any information regarding unsuccessful job applicants. And the wheels are turning, and you're wondering the distinction between the successful job applicants and the unsuccessful. Remember, we went through information that must be made public without a request, and we had their job titles. So here, if the applicant is unsuccessful, then the information is not supposed to be made available, not supposed to be made public. But if that individual is successful, has been employed, then it goes back to that information that we started off with of it being made publicly available. Exemption 2A, body-worn cameras. Any body-worn camera recordings recorded by the Metropolitan Police Department, MPD, inside a personal residence or related to an incident involving domestic violence, stalking, or sexual assault as defined by the DC Code. Exemption 3, law enforcement. Investigatory records compiled for law enforcement purposes, including records of the counsel investigations and investigations conducted by the Office of Police Complaints. These records, if they would disclose investigative techniques and procedures not generally known outside the government or endanger the life or physical safety of law enforcement personnel. Exemption 4, agency communication, interagency and intra-agency memorandums or letters which would not be available by law to a party other than an agency in litigation with the agency. And as we move along, we'll see how third party might step in a little bit with the another aspect that we will discuss corollary. But let us look now at exemptions 5 and 6. Exemption 5, future examination test questions. Exemption 6, information specifically exempted from disclosure by statute other than DC FOIA, provided that such statute requires that the matters be withheld from the public in such a manner as to leave no discretion on the issue or establishes particular criteria for withholding or refers to particular types of matters to be withheld. And so it's clear from these statutes that the information is exempted. The information must not be made public. And note that this exemption applies to statutes and not regulations. And we'll just go through these exemptions a little faster. Exemption 7 through 9. 7, national security matters under federal law. 8, antitrust investigations. 9, arson investigations. Likewise, for exemption 10 to 12, we'll go through faster. Exemption 10, emergency response plans. Exemption 11, social security and federal employer ID numbers. And exemption 12, whistleblowers, unless the name of the employee is already known. Likewise, exemptions 13 to 15, 13, Homeland Security records, 14, sealed criminal records, 15, critical infrastructure, and it applies only to entities regulated by Public Service Commission. Exemption 16, that's teacher evaluations, DC official code, the section is there. Legal exemptions. And one of the legal exemptions is attorney work product. And you can see how this will tie in readily with exemption 4. Attorney work product applies to documents prepared by or for an attorney in anticipation of litigation, no matter the status or stage of the litigation. Attorney-client privilege protects communications between an attorney and client when the agency is the client and when privilege is necessary to obtain legal advice. Legal exemption continues. Now we are looking at the deliberative process privilege. Again, you can see how this readily ties in with exemption 4. The method through which an agency creates policies, opinions, rules, and regulations. And to qualify for this exemption, the record must be both pre-decisional and deliberative. Pre-decisional documents are those generated before the adoption of an agency policy. A document is deliberative if it is a part of the agency's give and take process by which the decision itself is made. And we see how the two of them are closely tied. This is the one that we spoke about a little bit earlier, consultant corollary. So third-party communications and the deliberative process. The deliberative process does not generally apply to communications that include third parties. Communications that include third parties may only be withheld under the deliberative process privilege under the consultant corollary if the third party has no independent interest. Their interest is aligned with the government. And so this third party extends to government agencies. Well, it extends to situations that are similar to contract, but it may not involve a contract. And so this organization, this third party, is acting solely on behalf of that government agency. It's not advocating, it's not looking out for its own interests, totally aligned with the government agency. Third-party communications and the deliberative process. And this is from a case, McKinley and Board of Governors. Another case that I read a long time ago, as a Department of Interior case, is also instructive on this third-party communication. In this case, McKinley, in the typical case in which a court applies the consultant corollary, the consultant does not represent an interest of its own or the interest of any client when it advises the agency that hires it. The consultant's only obligations are to truth and its sense of what good judgment calls for. And in those respects, the consultant functions just as an employee would be expected to do. GLOMAR responses. When you hear GLOMAR, you think neither confirm nor deny the existence of records. And so Acknowledging the existence of records would itself divulge protected information. This goes back, there is a C1 exclusion. It's not applicable in DC, but for those who will ever work on the federal side, this somewhat reminds of that C1 exclusion. So in your response letter, you're going to provide this term, this phrase, this sentence, can neither confirm nor deny the existence of responsive records. Search may not be required if all potential responsive records are entirely protected. And so you know that all the records that have been requested, these are entirely protected, because if I ever acknowledge the existence, even if I know that certain information is exempted, but if I ever say such, then it would divulge certain information. And so I also use caution, because there are times when requests include the information being requested includes non-exempt records. So you want to be cautious. You want to have a keen eye. You may want to jump to neither confirm nor deny, but make sure that it is so, that it's warranted in that situation. Producing the records. So if you're going to produce records, we know we have gone through a lot of things. We know that we are clear on what is being requested. The requester knows that we are working on his or her requests, and we have retrieved those records, and we have redacted, or as the case may be, reviewed those records. So producing the records, a FOIA response does not have to provide answers to requesters' questions disguised as a FOIA request is in response to an individual request for information. The agency's obligation in meeting a FOIA request is to provide access to records. Do I have to create records? No. FOIA does not require an agency to create documents or opinions in response to an individual's request for information or to obtain records from another agency. A case on point here, Dugan against DOJ. Decision letters. Whoopee! We are moving along, effectively managing the FOIA process. You know you're doing well because you're at the juncture of preparing your decision letters, getting ready to dispatch your decision letters. What is required in an agency decision letter? The agency decision letter should contain the following information: whether the record was released in full, in part, or withheld in its entirety, the name and contact information of the person who made the decision concerning the release of records, a reference to the DC code provision that is the basis of the decision. And so exemption 2, exemption 4, but state the exemption. What does it state? You know, the reason why you're applying this exemption. Also, you may have different records. You may have a letter. You may have contract. And so you're going to describe the document and not just lump them together and put all the exemptions together without connecting. You must connect the exemption with the record and provide the reason why that a portion or all of the document is being withheld. A statement advising the requester of appeal rights. Decision letters, what to do, what not to do. Do not use the language if construed as a denial when you are very clearly denying the request. And that's confusing. And so if you have been using that language, you know, go ahead and remove it and have your template created for those denial letters. Do not withhold multiple records using multiple exemptions with a single omnibus sentence. And that's what we just went through earlier. So an example is here. DCMR requires that you identify which exemptions apply to which records. And this is the FOIA process in a nutshell here. We are recapping. you receive the FOIA request, and you know when you receive that FOIA request, you are going to look at it carefully to ensure that it is clear, no ambiguity there. Decide whether you require clarification. So you receive that request, you log the request internally, you create a case file. That's where you have that tracking number, you estimate the fees, and you send that acknowledgement letter. And remember, if you require clarification, you can do so in that acknowledgement letter. Or step 3, retrieving the records. You search for responsive records. You'll request the records if you have to request for another office within your agency. And then you set out to review those records. And step 4, processing the records. You make the necessary redactions, apply your exemptions. And so when you redact the records, you don't just make a redaction there and leave it without more. You put that exemption code on the document. And so when you're preparing your letter, then it's that exemption code that you must address in your letter. Then you don't just put the exemption code in your letter as we discussed earlier, but you write out what it states and how it applies to that particular document. You calculate your fees. Now we are at step 5, approve release of records or deny. So you draft your response letter that includes fees or grant of fee waiver, and you release the record. And we spoke about fees earlier, that if that requester has a track record of not paying on time, or that requester has outstanding fees, that at this time you may require that fees be paid before the records are released. And our contact information is here. As I mentioned earlier, Director of OOG is Nicole Allen, Chief Counsel Louis Neal, one of the attorney advisors, Joan Lelma, and the other attorney advisors are Anthony J. Skirbo, Brandon Lewis, Kimberly Brown is a paralegal specialist, and Kevin Brown, IT specialist. Our address is here. If you have questions, please feel free to reach out to us. And our website is open-dc.gov. Our email address, opengovoffice@dc.gov. Telephone number is there as well. And we have more coming for you in this series. So the next training will be on June 26th, and this one will be presented by Anthony, titled DC FOIA Basic Training for Beginners. And then in the summer, from July to August, on specific days, we will have a training series where all the members of staff and Director Allen will be presenting at that time. And Ethics Week is in October, a week in October, and that week is still to be determined. We'll let you know as soon as that information becomes available. And December 18th will be the FOIA Officer Holiday Gathering. So we're looking forward to presenting more, interacting with you. And we're at the point now of if there are any questions. Thank you again for joining us for this training.
Thank you so much, Joan, for that presentation. If there are any questions, please feel free to ask them now. Or if you can't, please feel free to email any one of us at the information that Joan gave you, and we'll be happy to answer any questions that you might have.
Thank you, Lois.
Hello, I have a question. Can you hear me?
Yes, Ms. Jones, please go ahead.
How's everyone today?
Fine, thanks.
I want to know if someone submits a simple FOIA request, like I want Katrina's personal address that your agency records show, and that's really it. They don't provide any additional information to confirm one way or the other whether they meet any of the exemptions. It sounds like the rule of thumb. Let me rephrase that. My initial reaction would be to deny it because they have not submitted anything to establish that they meet any of the criteria for any of the exceptions. But is it a better approach if they submit such a simple request to inquire for more information? And I ask that because I wonder if that's going to extend everybody's time who just submits a request and doesn't know that they need to be that specific.
Well, the threshold for denial there, it wouldn't be that the requester has not demonstrated that an exemption is applicable. It would go to, is that information sufficient? Has the whatever is being requested sufficiently described? And so the foremost thing is not the application of the exemption.
Okay.
Yes. So is that clear, Ms. Jones? Do you have another example?
I'm just not sure that that's helpful in any way, especially when some people don't know how to ask for what they want. And it sounds like it would require
clarification. In that case, it would require clarification in lieu of outrightly denying, because when you ask your question, you alluded to exemption. Like you look at it from the outset and you said, well, an exemption doesn't apply. But what you're looking for at that point is, what is this person requesting? Is this request clear? Has it been sufficiently described? And if you get a request and it can go three ways, or you look at it and you are like, at first blush, oh, this is what the person is requesting. You go to lunch, you come back and you look at it and you change your mind, then you know that it's best to seek clarification. So if it's a situation where clarification is required, go ahead, seek that clarification. You can do it in your acknowledgement letter. You can also reach out via email, telephone call. If it is someone who you have, request relationship, so to speak, a frequent requester, then you will know the best course of action, how to reach that party. And in your situation, it sounds as though I was just reading the chat. It sounds as though it would be someone who is someone who has never requested information. And so that is what I would suggest. If it is, when you look at it on the face of it, you know assuredly that this is not my agency records. This is another agency. So you know that's an NIF, no information, and then you can point that requester to the appropriate agency.
So I'll probably have this conversation offline, because the information that they've requested is what we house. It's someone's personal residence address, but it was really just a one sentencer. And so maybe I just need to have an offline conversation and better understand how to approach those particular ones.
Okay, I think I can speak a little bit more on it. And if you'd like to speak offline,
okay,
I'll do that. So if it's someone you can identify that information, you know the party information they are requesting, even though when you look at it, you see that, okay, this information, I have to withhold this information, you still go ahead and you process the request accordingly.
Okay. Okay.
Yes. So
right. Thank you.
You're welcome. Let's see if there are any other questions.
Yes. Good afternoon. My name is Erica McJimsey, and my question is not directly related to responding to FOIA, but particularly in regard to the database that's used. Are there any training materials in regard to how to access the FOIA portal?
Yes. If you go to our website, open-dc.gov, you will find instructions there.
Thank you.
You're welcome.
Hi, this is Christina Dalton. I have a question.
Yes, Christina.
And it's kind of related, I guess, to production. So I guess with DC and the, I guess, impending possibility of furlough, I know when we went into the pandemic, there was a moratorium kind of put forth. Is that something that might possibly be put in place if, um, if forced furloughs are imposed on the district?
I would imagine so, Christina, because efficiency, as we spoke about, timeliness, accessibility, but in a case where FOIA officers aren't able to operate the way that they ought to, then I would imagine so. But when we get to that point, when we get to that juncture, we'll provide the information as soon as we receive it. We always provide updates on our website at open-dc.gov, the news, even as it relates to statutory changes, recently dealing with the OMA. So we always provide updates there. So when we get to that point, and I don't know if Chief Counsel Neil and I don't know if Director Allen is still here. I would like to speak more on that.
Hi, this is Director Allen. Yes, I'm still here. With respect to furloughs and other issues that may arise and impact the ability to respond to a FOIA request because we are not in the office, yes, that would require a legislative change. So a temporary or emergency legislation would have to change the FOIA statute. As some of you all may remember, that did happen under the COVID emergency rules. So that's something the mayor would have to request the council to do, or the DC council would have to do on their own. I'm not aware of any push to do that right now, but if, as Joan said, if we find out anything, we will let you all know as soon as we do. But hopefully, that will not become an issue. But that's a great question. Thank you for raising.
Thank you.
Are there any other questions? And thanks to my colleagues who have answered these questions. I see here in the chat the responses. And again, thank you all for joining us for this training.
Oh, sorry. Can I ask one last question?
Yes.
Hi. Sorry. My name is Zach Hill. I'm with the library. So I'm relatively new to FOIA, and I've found BEGA's advisory opinions extremely helpful, as well as the mayor's appeals decisions. I have noticed that the mayor's legal office, MOLC, their pre-2022 appeals decisions are in like a very easy to use searchable database, but any appeals decision they issue post-2021, they just upload into Box, and it's not searchable and therefore not super user friendly. I have contacted MOLC about this and I've not heard back. And I guess I'm just wondering if BEGA has tried providing sort of friendly encouragement to MOLC to make their appeals decisions searchable and a better resource for the rest of us.
Hi, Zach. I can, I'll chime in on that, Joan, because that was actually a matter that we were dealing with. So to answer your question, yes, we have been in contact with the MOLC. We had some ongoing conversations with them because the issues were raised by some of our partners at the Open Government Coalition concerning the searchability of FOIA records and the publishing of some of their appeals. That is an ongoing process simply because there was a pretty huge backlog. And so they are refining their system to publish these FOIA appeals. Now, it's my understanding that they have made great progress with these. So I'm not sure exactly what difficulties you may be experiencing right now, but we are happy to take any concerns that you have, and because we have a great relationship with the folks over there, since we are basically partners with this FOIA, with these FOIA matters with them. If you can forward your questions or your concerns, and we can research that, and I'll be happy to get back with you.
Oh, that'd be awesome, and that's great to hear. And yeah, I can shoot you an email.
Absolutely. Thank you, Zach.
Thank you.
Mhm.
Thanks, Louis.
Mhm.
And if there are no other questions, again, thank you for joining us for this training, and we look forward to seeing you at our next training, and thereafter for Ethics Week. And we look forward to that end of year gathering as well. Have a great afternoon. Goodbye.